SwayamPrabha. Digital India. Educated India.
Welcome students. Myself Dr. Amrendra Kumar Ajit, Assistant Professor Senior Grade from Faculty of Law, University of Delhi. Today I will deliver the 9th lecture on Transfer of Property Act, and topic is Ostensible Owner. The concept related to ostensible owner is given under section 41 of the Transfer of Property Act. Okay. Actually, this provision is mainly a kind of equity that when some person is behaving like owner and then he is transferring the property, then transferee will have good right over that property whatever has been transferred, whereas the real owner is someone else. So, I am going to discuss in detail through a statutory provision and case law the concept of ostensible owner. This section says, section 41 says that where with the consent express or implied of the person interested in a movable property, a person in the ostensible owner of such property and transfer the same for consideration. The transfer shall not be voidable on the ground that transferor was not authorized to make it. Proviso is that the transferee, after taking reasonable care to ascertain that the transferor had power to make the transfer, has acted in good faith. So, this is the condition 1. But prior to that, within the provision itself, there are so many conditions. So, first of all, I will discuss about the concept of ostensible itself. The general meaning or colloquial meaning of ostensible means apparent or seeming or looks like. Okay. So, when we talk about ostensible owner, that means it is very clear that the person who is acting like owner, but he is not owner, and he is doing all the things like owner, okay, but actually he is not owner. So, in other words, a person may have possession and enjoyment of property and his name may be entered in the official record also, but he may not be the true owner of that property. Okay. So, the concept of transfer by ostensible is based on two principles, that is nemo dat quod non habet and nemo plus juris and alium transferi protest quam ipsa habet. The meaning of this maxim is that any person cannot transfer the title, better title than what he has. Okay. So, every person is entitled only to transfer up to that much what he has the title. So, ostensible owner has no real ownership, but he is transferring the property presuming that or assuming like owner, and there is a kind of consent from the real owner. That means, whatever this ostensible owner is doing, that means there is expressed implied consent from the real owner, then only he is doing, otherwise it will be a kind of fraud. So, but purchaser has no knowledge of it. That means, this real owner an ostensible owner, they are knowing their authority, they are knowing their nature of this rights on the property, but purchaser was not aware of all these things, and purchaser had its knowledge that ostensible owner is has this kind of right and he is good person to transfer it. So, in that case this transfer will be a valid one. So, I am going to discuss in detail. So, first case before the Privy Council on this subject, that means when this act was not in existence itself at that time, that Ram Kumar versus McQueen. Okay. So, in this case the Privy Council explained that it is a principle of natural equity which must be universally applicable, that where one man allows another to hold himself out as the owner of an estate. So, first of all, principle of natural equity which must be applicable universally. That means, when there is a principle of equity, certainly it will be applicable universally, where one man allows another to hold himself out as the owner of an estate. That means, one man means real owner here, allows another, that is ostensible owner, to hold himself out as the owner of a estate, and the third person purchases it for value from the apparent owner in the belief that he is the real owner. The man who so allows the other hold himself out shall not be permitted to recover upon his sacred title unless he can overthrow that the purchaser by showing either that he had direct notice or something which amounts to constructive notice of the real title, or that there existed circumstances which ought to have put him upon an inquiry that if prosecuted would have led to a discovery of it. Okay. That means, purchaser should be a bona fide purchaser. Okay. If bona fide purchaser means, it means what? That the purchaser has purchased the property knowing the things that the ostensible owner is the real owner. Okay. And he was not aware with the real title. So, in that case, this doctrine of equity says that if the person has done transaction in good faith with proper consideration, then the right of transferee must be protected. The right of transferee must be protected, and in that way this law was enacted. So, first of all, it has been developed through the law of equity, through the judicial precedent. Ultimately, it has been incorporated in the Transfer of Property Act in 1882. In Muhammad Shakur versus Shah Jahan, the court said that in this case, where the real owner of the property lived in a different village from the property and they had authorized a widow to use the said property in question, the way she liked and afterwards in future she sold this said property in question, under this case the real owner lost the claim over the property and the transfer was a valid one. That means, in this case what the court had said, that the real owner was residing in different village, his property was in another village also, but he was not personally taking care of that property. So, that property was given to a widow to maintain that property. So, all the villagers and nearby, they were knowing that she is the person who is taking care of, or she is the person who is owning the property, and who is the real owner, it was not known. So, in that case she sold that property to third person. Okay. So, real owner may not be the knowledge of the selling by the ostensible owner. Okay. It is not necessary that there will be, but yes, he is ostensibly holding the property, that is through the consent. Okay. So, holding the property as ostensible owner must be in knowledge with the real owner, but what he is going to do, it is done by the permission or without permission, it is immaterial. So, if suppose he is doing without permission, in that case he may do with the permission also, okay. But if he is doing without permission and giving the property to third person, in that case third person is behaving in good faith, acting in good faith and purchasing the property with certain consideration, then the right of transferee must be protected. And here it has been told by the court that whatever has been done by the widower to and that property has been sold to the third person, that will be a valid transaction. Okay. That means the lady was in ostensible ownership, and being a ostensible owner, she has transferred the property, then real owner will be liable to validate that property. It cannot, okay, and that transfer was valid transfer. So, the Supreme Court in Crystal Developers versus Asa Lata Ghosh in 2004 said that a property was transferred to a person under a will and he obtained a probate. He did so without informing the other intestate heir of the testator, but those here allowed him to represent to the developers that he was the owner of the property. Okay, because there was certain heirs, there was certain shares in that property by the other shares also, but other here given the consent that the person to whom the will has been made, that is representing them all. But those heirs allowed him to represent the developers that he was the owner of the property. He sold the property to the developers. It was held that the developers, having acquired the property in good faith with valuable consideration, interest, legal heir were stopped from the challenging the validity of the transaction. Okay. So, in this case you will find in ostensible owner that this is also a kind of principle of estoppel, nearby to estoppel. Why? Because in estoppel is the rule of evidence, and under section 115 of Indian Evidence Act, it is said that if someone is pretending that it is his own property and later on it come to that person, then he cannot deny his promise. In same way, more or less, it happens in the case of ostensible owner also, because the ostensible owner is represented on the behalf of the real owner, and other is presuming that this person is the real owner. Okay. So, in that case what happened, if the third person acted believing that that person is the real owner, and because he was the authorized by the real owner, whereas ostensible owner has been treated as real owner by the third person, then the transaction will be valid. Why? Because now it will be stopped, this ostensible owner will be stopped to say that this property does not belong to this real owner will be stopped from saying that he will not accept this transaction. He cannot say like that. Why? Because according to his authority only ostensible owner is doing all these things. So, once he has recognized the authority of ostensible owner, then whatever is going to be done by the ostensible owner on the behalf of real owner, the principle of estoppel will apply. Okay. But there is a certain difference between this principle of estoppel and this section 41. Okay. What is that? It says that under section 115, it is necessary that the party sought to be stopped should have intended that the party pleading the estoppel should act on his representation. Okay. That is the necessary condition under section 115. That means, if someone is giving representation or saying something, then the other party must acted upon it, then only he will be bound by that. Whereas in section 41, it is not necessary that the real owner should have intended that the transferee should take a transfer of property. So, here it is not necessary. So, I told you that ostensible owner may say may do these things with the permission of real owner and may not with the permission of real owner. So, there may be the two possibility in this case. First, that the same property is going to be transferred by B. B is going to transfer this X property of A. B is ostensible owner. So, this may be transferred, X property may be transferred with the consent of A, it is okay. Even in that case, because the purchaser C is not knowing the this reality that A is the real owner, A is the real owner. Sometime it's happened. What happens that some person has been given that authority that he will take care of that property. If someone is residing in a foreign country, so he will nominate someone, he will, and that nominated person will act like that ostensible owner. Okay. Sometime they may be the authorized agent also. Okay. So, if he is like ostensible owner, then he may sell through with consent and may not sell with a consent. B has both kind of them. If the B is selling with the consent, it is okay. But in some cases, he may not sell without the consent of A. Law will be same in both the case. That is section 41 will remain same, it will not affect at all. Okay. So, section 41 talks about both type of the condition, whereas it has been said that where in this section under section 41, it is not necessary that the real owner should have intended that the transfer should take a transferee should take a transfer of property. So, it is not necessary that there was his intention, there was his consent to sell, but ostensible owner did it. Then in fact, in the most cases the intention of the person placing property in the name of another person, that is ostensible owner, is to screen the property from the creditors and not the ostensible owner should transfer the property to anyone. So, earlier this kind of things it has been said that ostensible owner generally it has been came to protect the interest of the real owner. Generally real owner purchase the property on the behalf of on the name of other, okay, to save himself from the creditor. So, this was the rule. This was the one of the reason. There may be other reasons also. Later on in due course, what has happened that some this ostensible owner took the very negative form, that the person who is accumulating the property through corruption, they started the purchasing property on the name of others when they have remained as the real owner. Okay. So, for that purpose, that for restricting that, there was a Benami Transaction Act came in 1988. I will discuss at the later part of this lecture. Okay. So, now we will focus on section 41 itself, that essential what are the essential requirement of section 41 now. So, first requirement is that there must be the ostensible owner, then transfer of property to the ostensible owner must be with expressed and implied consent of the real owner. This is the main one of the main important point, where it has been said that certainly there is a transferor must be an ostensible owner. There must be ostensible owner in the picture, and that ostensible owner must be appointed, or he is in that position with the consent, whether it is expressed consent or it is implied consent. So, with the consent of the real owner, the transfer by the ostensible owner must be for consideration. That means, whatever has been transferred by the ostensible owner to the third party, the third parties had paid some amount about that immovable property, and next and last is transferee must have acted in good faith, taking reasonable care of ascertaining that the transferor has the power to make the transfer. That is also important. That is fourth criteria of it. Okay. So, if in any transaction, if all will be fulfilled, then only it can be said that this section 41 will apply. So, what are those conditions? Now, one by one we will discuss in detail. So, first is about the ostensible owner, that means transferor must be ostensible owner. Transferor, that means who is transferring the property. Here the real owner is not the transferor. Transferor, because ostensible owner is under the possession of property, okay, and he is reflecting himself or she is reflecting herself as she is the owner of property and she is transferring that to the third person, and here it is transferee. So, question here is that how it will be determined that who is the ostensible owner, because sometimes it is a very difficult to identify that who is the real person and who is the ostensible owner. So, in some cases it will be very clear that okay, person has given the money and you will to another one, and that person has been appointed as ostensible owner through the consent and all. But when the matter used to go before the court, then situation will be like that how to identify that whether he is the real person, real owner, A is the real owner, or B is the real owner, or B is only a ostensible owner. Sometimes it may happen that ostensible owner will claim also himself or herself as a real owner. So, at that time this will be a problem. So, for that purpose Supreme Court has laid guideline, a test in the case of Jaya Dayal Poddar versus B.B. Hajra in 1974. So, certain test has been laid down that how to identify whether whether a particular person or transferor is a real owner or only a ostensible owner. So, for that purpose first it has been said by the court that see the source of purchase money, that means who have given or who has dealt with this that particular property. Purchase money of what? That means purchase of money of not the transferee here, purchase money here it is of the purchase of the property, that who has purchased that property on whose on this ostensible owner is claiming right, okay, with who has paid that. So, first of all see the transaction detail, okay, that the money has been given by whom, whether the ostensible owner has given the money or the real owner has been given the money, okay, who are claiming the real owner. So, first of all this is the test that who has gave that money, that means who has really purchased that property by giving proper consideration. Second is intention of purchase. What was the intention of purchase? Why that property has been purchased? Okay, why it has been purchased means means here, that means what is the use, for what purpose it is, whether the real owner has certain purpose for it, for purchasing it, or the person is claiming as a real owner or ostensible owner, what is the purpose of that purpose, why that property was purchased. Okay, sometime it may happen that the third is a third test is that who in reality is enjoying the benefit of the property, okay, that who is using that property. So, sometimes it is ostensible, in case of ostensible owner it is very difficult, third test is very difficult. Why? Because possession generally remains with the ostensible owner. So, when the possession generally remains with the ostensible owner, then generally prima facie it looks like that the ostensible owner is taking benefit from the that particular property, but sometimes it may not happen. Why? Because there may be the direction from the side of the real owner that whatever the benefit will accrue, that will be transferred to the real owner. So, in that sense who is going to get benefit? Sometimes it may happen that okay, the property has been purchased by the real owner, but ostensible owner has been kept as an caretaker, that you will take the care of the property, live there, use the benefit which is coming from the this land or building, and then after whenever there will be requirement to transfer on it oneself or any member of family, then it can be done. So, it must be also traced that who is enjoying the benefit of the this ostensible, who is taking the benefit from the that property which is in question. So, relationship between the parties, this is also important, that both are claiming kind of real ownership, or so in that case what is the relationship between parties? Is there any kind of relationship? That means they are relative, they are known to each other since long time, then it is, or what kind of relationship they are now continuing with. Okay. So, that should be also seen. Generally what happen in case of ostensible owner, that that property is purchased on the name of relatives. Okay. That means the property is going to purchase on the name, because it is a kind of ostensible owner, he is a ostensible owner. So, it has happened that when a person real owner is want to create ostensible ownership over that property, then he will not keep any person on that property as a ostensible owner. Generally it is kept from the relatives, okay, or very trusted person. Why? Because he is investing the money and ultimately he is going to take the benefit of it. So, ostensible owner is merely an ostensible instance, okay. That means it looks like, but actual control is in the hand of real. So, the person would be like that who should be under the control of real owner. That means whatever the real person will tell, that ostensible owner will do. Otherwise, if you transfer put the name of ostensible owner, any person, and there is no trust over that person, then certainly it will create litigation over the property. So, generally what's happened, that they used to keep the name of relatives, near relatives, or friends, or business partner, or any kind of corporation what they have created, any firm, so that their property should be within the control of the real owner. So, that relationship is must to check. Then custody of the title deed, that who has this custody of this title deed. That means when the property has been purchased, after this registration of the property, who is keeping that title, whether the title deed is with the ostensible owner, or the person who is claiming it, or it is with the real owner. Certainly generally the title deed will be kept by the real owner. Why? Because the property actually belongs to him. Even though in revenue record and in some cases it has been seen that revenue record is not the record for the ownership. So, sometimes it may happen that person who is purchasing the property, they used to go and see that that person is in the revenue record, or name of the person is in revenue record, but actually he is not the owner. So, why it's happened, that the purchaser is the owner and he has kept this title deed with him. So, it give a false representation that the this person is ostensible as owner, and false representation that ostensible owner is working as a real owner. Okay. So, conduct of the parties in dealing of the property, that is also important, that what is the conduct of party dealing with the property, that means how they are accruing the benefit, who have a right to alienate it, in that who can transfer it, who can lease it. So, all these things will be taken care at the time of deciding that who is the ostensible owner and who is the real owner, if there is a conflict. If there is no conflict, this test will not apply, because that will be the mainly it is through the mutual consent of the ostensible owner and real owner. But in once the conflict will arise, once the ostensible owner will start saying that I am the real owner, in that case these tests are applicable. So, in the case of co-sharer, the ostensible owner must have the consent of all co-sharer. This has been decided by the Supreme Court in various cases. That means, once the property is within the co-sharer, okay, or suppose it is a property of Hindu joint family in another village. So, the property will belongs to all co-sharers. So, whoever is pretending itself as a ostensible owner, the consent of all co-sharer is must in that case, and the burden of proof for this benami transaction or ostensible transaction is on the real owner. That the burden of proof that I am the real owner, it will be proved by the real owner. Okay. This ostensible owner is also a kind of benami transaction. Okay. So, the purpose was very beautiful when it was enacted. The objective was very pious objective at that time when it was created. Reason was very simple, that in some cases it was used to happen that the transferee purchased the property with good faith, and ultimately the real owner is a different one. So, this is mainly created for the protection of interest of the transferee, but how it has been taken into negative sense, that after independence we can say, when corruption started in the system, then the corrupt officers, corrupt politicians, they started purchasing the property on the name of other. That means, they were purchasing the property, but actual name of the owner was different, and this is called Benami transaction. Okay. Benami transaction, that means the name is of the other person on the document. So, in that way what happened, the person started protecting their own interest, real owner started protecting their own interest by creating this Benami transaction. Okay. So, it has been said that the burden of proof will be on the owner, real owner, to prove that he is the real owner, and he may prove through the title deed. Okay. Then he may through evidences that this property was purchased by him, he has appointed the ostensible owner, he has given expressed or implied consent to the ostensible owner to remain in the possession of the property. So, the court had decided so many situations in which it has been said that that will not fall under the category of ostensible owners, because they are either restricted or qualified owner. Okay. What are those conditions? So, take the example here, a manager in possession of property. So, manager is not ostensible owner. Licensee in possession of property, licensee is not a ostensible owner. The menial servant in occupation of the property, the person who has kept for taking care of the property and all, he may not be treated as ostensible owner. A professed agent, that means a property has been given to someone else to sell it, real estate agents and all, then he cannot be this ostensible owner. A manager or trustee of an idol, they have also not said as ostensible owner. The donor who has not reserved to himself any power of revocation of the gift deed. A co-sharer in occupation of the joint family property, a mahant of a mutt property, they all have treated as real owner, sorry, not ostensible owner, they may be the restricted user or they may be qualified owner to some extent, but they are not ostensible owner. So, in this case those persons are also included just like manager or licensee, because their nature is completely different, they are not ostensible in nature, but sometime like mahant and co-sharer, when they are the actual owner, but so they will be not treated as ostensible owner. Next point is expressed or implied consent, okay, of the real owner. So, consent must be real, and for any contract we know that there is a requirement of free consent. So, whatever the essential required for the free consent, that must be here also. Here also means the consent between ostensible owner and real owner, because here there is a requirement of implied or express consent of the real owner towards the ostensible owner, that he is knowing about it, that that person is ostensible owner, and this is a kind of, there is a implied or express consent. So, it has been said that consent must be free from this fraudulent, coercion, force, undue influence and all. Okay. So, in case of real owner is in case the real owner is incapable of giving the consent, like minor or a religious endowments, no one can hold himself out as an ostensible owner of such property. So, if the property is belonging to minor or religious endowment where the consent cannot be given, okay, in that case there will be no ostensible owner of this kind of the property, that is property of the minor, property of religious endowment, etc. Okay. Then example here it has been given that a Hindu husband purchased property in the name of his wife B. Okay. A is husband purchased the property on the name of his wife B. The property, the land was entered in the name of wife in revenue records. After A's death, okay, after A's death, his widow B, whose name was on record, revenue record, okay, on revenue record B, mortgage the land to C. So, there is mortgage of property to C, who took the mortgage after due inquiry, believing in good faith that B was the owner of the property. So, C took that property with proper knowledge as well as consideration, proper consideration. Okay. So, C obtained a decree for sale on his mortgage and purchased that land, because property was mortgaged to C, C was unable to pay the loan, then C has sold that property. Okay. So, C took the decree for sale for his mortgage and purchased that land. Okay. But at the time D was in possession of property, for D has purchased the land in execution of money decree against A. So, A has also some money decree going on different court, and in that case D purchased this property X. Okay. X was the property purchased by A, which was given to went to B. Okay. And then after B kept here as a mortgage to C, and there was a loan something, and the money decree went in another court, and there is a D who is the purchaser of the same property. That means now D is getting through the decree of the court, and C is also getting that purchasing after the giving the mortgage money. So, purchase the land C. But here he was with knowledge that B is the real owner and with consideration. Okay. Then what happened? C's suit against D for the possession was decreed. C suit against the possession of D was decreed. Okay. D was the successor in interest of A, who had held out his wife B as an ostensible owner, and could not defeat the mortgagee, who was a transferee in good faith from the ostensible owner. So, in that case D was the successor in interest of A, who held out his wife B as an ostensible owner. Okay. B was ostensible owner. So, when the mortgagee has purchased that property with money and full knowledge, in that case this will be protected, transferring in good faith from the ostensible owner. So, what it says, that could not defeat the mortgagee. Okay, could not defeat the mortgagee. Who is mortgagee here? C is mortgagee, who was a transferee. Later on transferee, because he has purchased that property in good faith, and so C's interest will be not defeated because he has purchased, whereas D was knowing that A is the real owner. A took the money decree has already given against A to D. Okay. So, D was in knowledge of all these things with real, whereas C was kind of thing that he was knowing that B is the real owner, he is not a ostensible owner. Here there was knowledge to D that B is ostensible owner, A is the real owner. So, you can see here that the equity is prevailing over general rule. Okay, general rule, and this is the law. Transfer of Property Act is for this purpose only, to give justice. So, most of the principle you will see here, that whatever it has been incorporated, first of all it had developed through the judicial decision, okay, and then it has been incorporated under the statutory provision. So, the protection of interest of the transferee is must. So, where the D is knowing that A is the real owner, B is the ostensible owner, and then he has given the money, then and here C has purchased that property knowing that B is the real owner, okay, with good faith and consideration, then C right is going to prevail over the D. Next example, a Hindu, died leaving a daughter B, who took a limited estate by inheritance. A Hindu, died leaving daughter B, who took a limited estate by inheritance, certainly share, only some share. So, B made a statement to the revenue authority that age separated brother C, okay, age separated brother C was his heir and allowed C to take possession of the estate. B made a statement to the revenue authority that age separated brother C was his heir and allowed C to take possession of the estate, because C was the heir of that A's property and C allowed to B remain as under the C allowed C to take possession of the estate. So, C was under the possession of the estate of A, whereas B had this kind of the consent. On the death of B, her son claimed as the reversionary heir of A. Reversionary heir of A, that means now there was a share of B also in this, because the B was the co-sharer in that property, and now death of B. So, the heir of you can say here X of B now claiming the reversionary right. Okay. As from the heir of A, C was held not entitled to the protection of section 41, because his ostensible ownership was not created by the real owner A, but by the limited owner B. Okay. So, B has created a limited, B had a limited ownership, B had not a whole right over the property, B had only share of the property, but C was holding the all property. Suppose all property is of 10 bighas, and out of 10 bighas there was only share of 3 bighas of the B. So, this 7 plus 3 both were kept by A. So, B had a limited interest in this, B had a limited share in this. So, X cannot, so this ostensible ownership of C has been created by B, which has no full ownership. So, it has been said that section 41 protection will not be applicable in this case. Okay. That means, C was not an ostensible owner under this. When it was not an ostensible owner this, then in that case what will happen, that X will be completely entitled for the partition of complete share, and if C would have sold certain property as an ostensible owner, in that case also C will have to compensate to Mr. X, who is the legal heir of B. Transfer for consideration. Okay. The protection for this section is available only when the transfer is for consideration, that means in gratuitous where there is no consideration at all, in that case concept of ostensible ownership will not apply. So, this section will not apply. This protection is also not available to gifts, thus the real owner will not be precluded from denying a gift made by an ostensible owner. Now, good faith and reasonable care, which is the duty of the transferee. Whenever the transferee is purchasing, then first of all he is purchasing through consideration, and there must be good faith and reasonable care. Reasonable care means what? Reasonable care to identify that whether this ostensible owner is a real owner or not. Okay. That is very important in this case. So, what will happen, that all the reasonable care should be taken, that means he had no means to see or to think that ostensible owner is not a real owner. Okay. So, generally whenever anyone is purchasing the property, they go and see and verify the document, they verify the records. But even on the records, if it is found by C that the name of the ostensible owner is there, then what he can do? That means, he had acted on the good faith with reasonable care, then his or her right will be protected. So, it has been said the mere good faith is not sufficient. The purchaser must establish that he made a reasonable inquiries, that is important. Okay, reasonable care means such care as the person of ordinary prudence would take in his own case. It means such care as an ordinary man of business would take. Reasonable care is to be expected from everyone who claims to have purchased free from a really existing right. So, whatever he want to do as a reasonable man, any person would have done in that case, the same thing should be done by the purchaser here, transfer here under good faith, because no one is going to invest the money in any property without certain limited inquiries. He is not going to do the police investigation, okay, or like the bank officials investigation, but at the same time the reasonable care, reasonable investigation or inquiry is required on the part of the purchaser. So, A was the owner of the property which was entered in the revenue record in the name of B. The B mortgaged the property to C, who accepted the mortgage relying on the revenue register. If the C had made further inquiry, he would have found that A had objected to the entry of the property in B's name and the property had been left to A by will. C was not protected by this section. Okay. Where the transferee had knowledge of the fact that the land belongs to a lady who had a grandson, it was held that this fact of knowledge ruled out the application of section 41 and 43. Consent letter is not a document of authority even if it was found to be genuine. So, in these kind of cases where it has been clearly identified that there is a person who is not looks like a real owner, in that case this section will not apply. Burden of proof. So, burden of proof first of all lies in the transferee to show that the transfer was the ostensible owner and that he acted in good faith and with reasonable care. The onus then shifts to the party who wants to defeat the transferee title to show that there was something which called for inquiry and attention. So, in that way burden of proof will come. Now, come to the another important part of this section itself, that is Benami transaction provision of right to recover property act 1988. Why this is important? Because ostensible owner, that is also called as a Benami, you can say Benami owner, okay. Ostensible owner is a Benami owner. This practice increased in due course. So, due to this corruption money, most of the transaction which were protected under this ostensible owner gone as a this Benami transaction. Okay. So, it increased corruption in the system. So, for curtailing that, the government of India came with this Benami transaction provision of right to recover property act 1988. So, under this what is the Benami transaction? Benami transaction means any transaction in which property is transferred to one person for a consideration paid and provided by another person. The same thing, that means real owner is someone else, name of the property, name on which the property is going to be purchased is the different one. That means the purchaser, actual purchaser is different person and owner, the name of the property is on the different person. So, in simple word, the person who purchased the property and pays the price for it does not purchase the property in his own name, but in the name of any other person. Generally, it is the relative, friends, most trusted friends or their own maid company, firm, societies like that. So, other person whose name is used as the owner of the property is known as Benamidar, that is ostensible owner. In truth, he holds the property on behalf of the real owner because he is not the real owner. So, the Benami Transaction Act 1988 provides that where a property is transferred Benami, the person in whose name the property is held shall become the real owner. This was a act which says that when there will be a Benami transaction, that is ostensible ownership will be created, in that case now through this act, that means after 5th September when it was application date 1988, whoever is doing Benami transaction or whoever is purchasing ostensible, creating ostensible ownership in the property, that ostensible owner, this ostensible owner will be equivalent to real owner. Okay. Just a minute. Ostensible owner will be equal to real owner. Okay. Now, in this case what will happen? No one want to create this kind of thing, because whoever will purchase, whoever will purchase in that, whoever is going to purchase as a Benami transaction, the person on whom name this Benami transaction is going to happen, they may claim it as a real owner. So, now it is not necessary that it has been already controlled. Now, thing is that the person who tried to take the escape this act, they trying to transfer it on the most trusted person, near relative, but within the near relative also there are certain exceptions. So, this has been prohibited under section 4 of the Benami Transaction Act. Provision of the right to recover property held Benami, no suit, claim, action to enforce any right in respect of any property held Benami against the person whose name the property is held against any person, other person shall lie or behalf of that person claiming to be real owner of such property. So, there will be no such type of the suit will be entertained that he is saying that he is the real owner. Whoever is on the name on the document, that person will be the real owner. No defense based on any right in respect of property held Benami against the person in whose name the property is held against any other person shall be allowed in any suit, claim or action by or on behalf of a person claiming to be the real owner of such property. So, no defense will be granted, no any defense will be accepted against the Benami transaction. So, it was completely a hammer on the Benami transaction, okay, to restrict this kind of the practices, and only few exception has been given under this. Who are the person on the name of whom it can be purchased? Co-partner of Hindu undivided family. On the name of the co-partner of Hindu undivided family, property can be purchased. Okay. Then, where the person in whose name the property is held is a trustee or other person standing in fiduciary capacity, the property is held for the benefit of the another person for whom he is a trustee. Okay. So, in that case, this will be also protected, that a person is holding the position as a trustee and something is going to be purchased for the benefit for the person or for the property for which this trust has been created. So, in that case it is possible. So, only two exceptions are there. First is if something is going to be purchased for the co-sharer of the Hindu undivided family, and second is if there is a trust and property is going to be purchased for the trust under the fiduciary relation. So, this means that now the ostensible owner or Benamidar has become the real owner. So, except where he is a co-partner in Hindu undivided family or trustee standing in a fiduciary capacity, the law laid down by section 41 of the Transfer of Property Act stand modify, except Benamidar is a co-partner or trustee standing in the fiduciary relationship. Okay. So, after 1988, okay, after 1995 September 1988, the role of section 41 is very limited. Section 5 is about the all property held Benami shall be subject to the acquisition by the such authority, any authority who is going to make an inquiry, such a manner after following the such procedure as may be prescribed. For the removal of doubt, it is hereby declared that no amount shall be payable for acquisition of such property. If someone has purchased the Benami transaction, someone has purchased the Benami property, okay, then any authority who is going to investigate related to the corruption and all, they can take the position, they can take that property and no amount shall be paid as compensation in that. Okay. So, that kind of the strict law has been created. So, Benami Transaction Act is not retrospective, that means whatever the transaction happened before the 5th September 1988, that will remain valid, but any Benami transaction after 5th September 1988, it is going to be struck down. Okay. Then section 41 exception will not apply, section 41 will not apply, exception will apply, that means for the co-partner and trustee. It is prohibitory in nature, not declaratory in nature, that means it prohibit the corruption, it prohibit Benami transaction, but it does not declare it that this transaction is Benami in nature. It try to this prohibit this kind of the transaction. Then with few exception is I have already described, there are two exceptions only. So, section 41 is now limited role for transaction prior to 5th transaction 41 is now very limited rule for transaction prior to 5th September 98. After transaction after 5th September 1988, only 2 exceptions are allowed. Okay, only 2 exceptions are allowed. So, in that way the Benami transaction, okay, has been tried to be curtailed, tried to be stopped. There is a recent amendment also in 2016 in the Benami Transaction Act, but that is only for making the enforcement part more powerful. Okay. So, it is not going it has been not there is no amendment in section 4 or 5 where they declare it as an illegal Benami transaction. They are declaring that whenever there will be Benami transaction, if any authority is going to confiscate it, there will be no compensation. Only the enforcement part has been amended, and now it is more rigorous, more enforceable, and in that way section 41 application is very limited, only prior to 5th September 1988 and after 5th September 1988 only in exception it will be applicable. Okay. So, thank you very much for this lecture, lecture on ostensible ownership and ostensible transfer. So, thank you all, thank you.